Assalamualaikum and good day to Firdaus. Today I'm going to present the case of Muthusamy V PP, 1948, MLJ 57. So the brief facts of this case is the accused, who is a lorry driver, was charged with house trespass with the intent to intimidate the complainants and also with assault under section 352 of Penal Code. The accused went to the complainant's house and protested against the alleged participations of the complainant's son in writing a petition against certain persons, including himself, the accused. After some arguments, the complainants asked the accused to leave his house, but he did not go and threatened to hit the complainant. The accused also made as though to strike another person with a torch, but the blow was averted. The Crown Counsel included bad character of the accused into the case. The learned magistrate then said in his judgment, evidence was brought that accused is a quarrelsome person and that he had quarrelled in the past and on other occasions. After conviction, it appeared that the accused had been bound over $50 to keep the peace period not stated. But this was 18 years ago. This was not a conviction and was too long ago to be ground of severity. So the issue of this case is whether the bad character evidence of the accused is relevant to the case. So for the decision of the case, Judge Taylor ruled that the magistrate had erred in making the decision. Evidence that the accused has a bad character is irrelevant during the trial. Therefore, the judge varied the consecutive judgment and released the accused on probation on giving security for his good conduct for 9 months. Reflection of this case is character means reputation and disposition, and the important principle in this case is bad character of the accused should not be taken into the account in criminal cases. Although there is no further explanation given by the judge, it has clearly shown that the bad character of the accused is not admissible, and this is also stated by the Evidence Act 1950 under Section 54. According to Section 54, in criminal proceedings, that the accused person has a bad character is irrelevant except in reply. Besides, a person charged and called as a witness shall not be asked, and if asked, shall not be required to answer any questions tending to his bad character, conviction, and commission. So it's clear that the general rule in this is evidence of bad character is not relevant. As mentioned by the Judge Taylor, the accused's bad character shall be brought in by the Crown Counsel for this case, and it is unfair to the accused. Furthermore, the evidence tending to show that he is a quarrelsome person and that he had quarrelled before and on other occasions is relevant. But there is an exception of this general rule. First, the statutory exception. If the bad character has propensity towards the act complained of, similar facts evidence, a fact relevant as showing the existence of the relevant state of mind must show that the state of mind exists not generally but in reference to the particular matter in question. The previous commission by the accused of an offence upon the trial is relevant. The previous conviction of that person shall be relevant fact. Second, if the bad character is part of res gestae, relevancy of the facts forming part of same transaction. In the case of Kanapati vs. R, if the evidence complained form part of res gestae, it is admissible as it is on entirely different footing to show that the previous bad character of the accused. The third one, if the evidence is part of the evidence motive, constitutes a motive or preparation for any fact in issue. In the case of Wong For Hing vs. PP, it was not rendered inadmissible merely because it tended to show bad character of the commission of another offence. In this case, there was only circumstantial evidence of the murder. Strong and convincing evidence of motive would probably have high evidential value. The fourth one is relevant of determination of criminal sentences. And the last one, bad character is relevant to rebut good character evidence under Section 53 and 54 of Evidence Act 1950. There are other cases similar to this case, such as Q Fumui vs PP, whether the convictions had been vitiated by the admission of certain evidence which was irrelevant, inadmissible, and gravely prejudicial, namely, evidence that at the material time the appellants were seen fleeing from the scene of the crime in a stolen station wagon. This was plainly evidence which could imply that the appellants were men of bad characters. That this evidence was inadmissible was plain beyond argument, as at no time during the trial was any attempt made by the defence to adduce evidence of the appellant's good character, nor had any attempt been made by the defence to impound the character of any of the prosecution witness. Second case is the case of Sankar aspirant vs PP. The evidence of the first appellant that the behaviour of PW17 and his friends were a nuisance to the occupants of the apartment is clearly evidence of bad character under Section 54 of the Evidence Act. It is gravely prejudicial and inadmissible. The trial judge is duly bound to stop the defence from adducing it, since inadmissible is always remain inadmissible whether objection is raised or not. And the last case is the case of Ramanathan Chelya vs PP. One may incline to the view that a handcuffed man in the dock will not appear to be innocent, but in practice, whether one is handcuffed or not whilst in the dock, the decision whether one is guilty or not is dependent on the evidence. Even his bad character is not relevant, as what's stated in Section 4 of Evidence Act. So the judge of the view that the trial of the accused can in no way be prejudiced, and his situation of being handcuffed in the dock does not determine the outcome of the trial. So the conclusion of this case is a person should not be judged strenuously by reference to the awesome spectre of his past life. Generally, bad character evidence is not admissible, but there are several exceptions that mention enable to prosecution to include such evidence. And it has to do with the alleged facts of the offence with which the defendant is charged, or is evidence of misconduct in connection with the investigation of prosecution of that offence.